interpretation that was given by the prosecutor on the crimes against humanity. The presentation was sharply, I would say, critical to the interpretation of the prosecutor and the decision of the prosecutor not to open investigation also with regard to the events in the eastern Ukraine, according to the second declaration. The presentation by Dmytro Koval concerned the role of the international criminal justice in the creating of the historical narratives, and he looked at that from the theory of the social systems and collective memory. The one important, I would say, thing that I really liked in this presentation was the idea that the International Criminal Court operates with signals and messages that are sent to the affected communities and the beneficiaries of the international justice. And I think it's very important in the context of Ukrainian situation, what is the signal that the International Criminal Court would send to the ground. The presentation by Gaynea Nurijanyan addressed the ICC competence in reviewing the completed domestic proceedings. She especially addressed the issue of the relations between the non-bis in idem principle and concept of admissibility and complementarity by International Criminal Court. And finally, Valentina Polunina touched upon the extremely interesting issue, maybe the crucial issue in the assessment of the possible ICC role in Ukraine is how the international criminal justice is accepted. I think the results of this research that was really promising. We see that we have the good momentum when the idea of international criminal justice is really well met by the Ukrainian society, and we have the good moment to move further. Finally, there have been some questions, and as a moderator, I use my discretion to ask the speakers what was the main reason why this investigation is not yet open. What is the obstacle to the moving further to proceed with investigation? And there have been different answers, but mostly the answer that probably this prioritization of the work of the court, and the prosecutor is probably not sure that this Ukrainian investigation could be success story for the office of the prosecutor. But I think that this was a very interesting discussion, and I hope that, especially the last presentation by the Valentina Polunina, that it's the idea of international criminal justice is accepted in Ukraine, would be available for the attention of the office of the prosecutor and generally for the International Criminal Court. So I think that the overall message of this workshop that we should wish this investigation to be opened, and we wish it the best success. Thank you.
Thank you very much, Professor Bogusz. And in parallel with workshop 1, we also had workshop 2, which dealt with a possible establishment of a truth commission for Ukraine. It was moderated by Mark Kirsten. Dr. Kirsten, you have the floor.
Well, thank you very much, and congratulations to everybody for making it this far. The finish line is close. I wanted to take this opportunity to once again thank you and to express my gratitude for being here, for having conversations with you. I've learned a lot. I deeply appreciate your time, and I look forward to a continued conversation. I will be brief. I'll start with the fact, the truth, that this was a great panel with great panelists. And it was very productive. And it was great, not just for what the panelists said, but also for what they did not say. So rather than speak directly to each of the panelists' presentation in order, I rearranged a little bit to speak a little bit thematically. So first of all, what didn't they say? The first point is that they didn't talk about, none of the panelists really talked about truth commissions as an alternative to trials, which I think is actually quite useful. Because typically we talk about truth commissions in opposition to trials, as an alternative to trials. That conversation wasn't framed in this way, which I thought was both interesting and actually quite useful. Second, it seems to me that truth commissions were not discussed in and of themselves as transitional justice mechanisms, but as a tool or a means to an end or a vehicle to address what seems to be the consensus problem, which is the issue of memory politics and conflict narratives. And secondly, to have a truth commission not necessarily as a means to achieve justice, but to absorb the past, which I thought was a fantastic phrase, and to confront the past, rather than to necessarily have to achieve accountability or justice in and of itself, to achieve some degree of collective truth about past events. Thirdly, the discussion wasn't really technical, which I thought was interesting. It wasn't on the technical aspects of truth commissions. It wasn't on whether you have an amnesty and if it's conditional like it was in South Africa. It wasn't on which types of perpetrators or which types of groups would be included in this process and which wouldn't. It wasn't about the crime base. It wasn't about how it would receive funding, what parliamentary laws would have to be passed to establish it. It wasn't about membership and who would actually be commissioners, even though I tried to get some of the presenters to respond, who is the Desmond Tutu of Ukraine's Potential Truth Commission? And the answer seems to be that there is none right now. And it was also very sober. So there was no romanticization of truth commissions. We often see romanticization of these processes, in particular of trying to have a superficial desire to replicate what happened in South Africa in other contexts. We see this a lot when groups and advocates talk about truth commissions. There was no starry-eyed kind of pie-in-the-sky expectation that this truth commission, this potential truth commission, would deliver all of these huge expectations. And I really commend the panelists for having a much more sober discussion about what a truth commission or a potential commission could achieve. All right. So what was it actually about? Now I've said what wasn't said or what was avoided. What was it actually about? Well, again and again, I think all of the panelists are seeking in various different ways, perhaps from slightly different angles, to find means to address, again, that root cause of the conflict, memory politics and conflict narratives, and the different historical collective memories that are in contention and in tension here in Ukraine, and seeing a potential truth commission, again, as a tool or a vehicle to achieve that. And here the participants were concerned not just with truth commissions as commissions, but also as a truth-seeking process. And they included in their analysis, which I thought was very interesting, various laws that have been passed recently, in particular, and including the decommunization law, and how this might fit into or actually pose an additional barrier to resolving memory politics, and how it might feed into some kind of truth-seeking process. And then overall, my sense was that through all the presentations, there were at least 4 major kind of planes or intersections that were at play. The big one is, of course, the temporality of any truth commission. So what time period would be covered? There was no clear consensus on this. There seems to be consensus that it should cover go back towards World War II and the Soviet period, perhaps even the interwar period. There's less consensus on whether it should include events that are ongoing. And I think this wasn't raised, but this does pose a question, because if you set up a truth commission now that deals with contemporary events, are you actually setting up a potentially permanent or very long-lasting truth commission, or do you give it a horizon that at some point it has to come out with the truth? Or do you have, which I think is an entirely other option, is you can have multiple truth commissions. So you have one for the Soviet period that allows a mandate to focus on that, and then perhaps one once this current conflict subsides and the political violence subsides. And then the second one, which I think has 3 kind of intersections, is who would be covered. So there was discussion about how Ukrainians have to have a process amongst themselves. Ukrainians and Russians have to have a process to discuss and to attempt to resolve some of these conflict narratives and these tensions over memory politics. And I think also, more subtly perhaps, but there has to be a discussion between Ukrainians and the West, in particular Europe, and how memory laws and various decommunization attempts fit into a wider narrative of Ukraine as a Western and European state. So then finally, in conclusion, it does seem to be, the discussion overall seemed to be more, and I think more usefully, as a conversation as to find ways, creative ways to change the narrative, creative ways to challenge memory politics through a truth commission, but without commissioning the truth. I'll leave it there. Thank you.
Thank you very much, Mark. And also, we are still in the previous day, yesterday. We had 2 more parallel workshops. Workshop 3 dealt with reparations for victims of the armed conflict. It was moderated by Judge Ksenia Turkovic. And Professor Tatiana Ansupova was one of the participants in that panel, so she's perfectly in a position to summarize the whole panel for us. So Tatiana, you have the floor.
Thank you, Professor Gnatovsky. I would like to thank one more time the organizers for inviting me to such an incredible event, which can influence not only one's awareness in some current legal issues, but also the worldview. Thank you for entrusting me with the task to sum up the discussion of yesterday's workshop on reparations for victims of the armed conflict. In the absence of our esteemed moderator, Judge Ksenia Turkovic, I'll try to follow up as close as possible her conclusions. So we've started yesterday from more general issues and have moved to more specific ones. Our first speaker, Vita Todeschini, has started from a perspective of complementarity between international humanitarian law and human rights law, as well as a victim-oriented approach to the question of reparations. He expressed the opinion that these perspectives may potentially help enforcing international humanitarian law, specifically the right to reparation by means of human rights law. Second speaker, Antal Berkes, referred to reach jurisprudence of the European Court of Human Rights in the context of concurrent applications, which were examined by the court from areas outside the territorial effective control. The procedure of the court, he proposed to such a thesis that the procedure of the court should settle those applications not in an isolated but in a coordinated manner, taking into account the underlying factual and legal background of the individual and interstate cases. In my presentation, I've analyzed the developments of Ukrainian legislation, of national remedies, and currently accessible instruments, legal instruments, as well as lacking an effective national comprehensive remedy in field of restitution of property rights. I also referred to the case law of the European Court of Human Rights, and I think it's obviously that this issue strongly connected to the issue of attribution of responsibility to the state, and I also referred to the case of Ilashko against Ukraine and some other questions. Finishing our discussion, Maxim Petrov, who replaced Alla Blaga, presented point of view of non-governmental organization, Ukrainian Helsinki Human Rights Union, in question of reparation for damage caused by the armed conflict in the east of Ukraine. And of course, the interesting questions continued the discussion, our discussion. For example, it was a question about the portion aid and involvement of different projects and donors in respect of this issue of compensation for destroyed property and houses. And it was a question, could it be compromised to give some portion support, and what consequences for the state parties it may bring, and with respect of obligations of state parties to the convention under Article 1, Protocol 1 to the convention. And of course, the main conclusion which Judge Ksenia Turkovich presented to us, she said that European Court of Human Rights really cares about its effectiveness, execution and implementation of its judgments. And that's why, as Professor Gnatovsky says, the magic solution which will come from international judicial bodies, it's not a good way of thinking for Ukraine, particularly in the case of Ukraine. And once again, referring to the principle of subsidiarity, the primary obligation of reparation for violations of an applicant's right under Article 1, Protocol 1 is to be found at national level. Thank you for your attention.
Thank you very much, Tatiana, for presenting the outcome of the third workshop. And in parallel with that workshop, we also had a workshop which was looking for a model of post-conflict justice suitable for Ukraine. It was moderated by Professor Sergei Sayapin. So, Sergei, you have the floor.
Thank you. Dear colleagues, and that workshop was really, really interesting. We had 5 presentations, which I could categorize under 3 headings. And interestingly, in our workshop, in contrast to the second workshop, there seemed to be trials and truth and reconciliation commissions did seem to be mutually exclusive for a reason that I will explain. So it seemed to me that 3 presentations could be grouped together because they dealt with different aspects of the same matter. That is, of a model of transitional justice, or models that could be suitable in Ukraine. One speaker suggested, to start with, all speakers agreed that whichever model might be adopted for Ukraine, this model must be integrated in Ukraine's judicial or administrative system. So that whichever model might be chosen, it should not be alien to the system, but it must be a part of the existing mechanism. Discussing the models themselves, the following issues were raised. First of all, the issue of the personnel. Now Ukraine already is experiencing a substantial lack of judges, and moreover, at least 2 laws were adopted in recent years that deal with the issue of vetting or lustration, whatever it might be called. And one speaker pointed to this fact, cautioned that competence must be sought among Ukrainian judges, of course subject to the implementation of these 2 laws, in order to make an applicable model as Ukrainian as possible. On the other hand, it was suggested that foreign specialists could be brought in, if need be, in order to supplement the Ukraine's staffing capacity in whichever transitional justice mechanism which might be adopted. These could be foreign judges, foreign prosecutors, foreign fact-finders, depending on the needs in the country. However, there was also a word of caution that sometimes foreign specialists are not guided by goodwill, by a true and genuine desire to help. Sometimes they might be guided by high salaries, by some other motivations which are not necessarily related to the administration of justice. Sometimes it was alleged that the treatment of national colleagues by foreign colleagues leaves a lot to be desired. Therefore, the staffing of such a transitional justice mechanism in Ukraine with foreign specialists must be well thought and unbalanced and must correspond to the actual needs. After that, there was a very interesting presentation that that put on the table the following question. One speaker recalled Minsk II, and his point was basically as follows. There is Minsk I, there is Minsk II. Minsk II provides for an amnesty. Therefore, where is the role of the International Criminal Court in prosecuting criminally persons responsible for serious violations, for crimes that were committed in the conflict in Ukraine? According to him, if there is, so this provision on amnesties being there in Minsk II, it effectively invalidates the competence and jurisdiction of the International Criminal Court with respect to Ukraine, because both the Security Council of the United Nations and the International Court of Justice in recent hearings invoked the validity of Minsk II, its legal force, its importance, and according to this speaker, Minsk II is an important factor that could potentially block any international criminal prosecution of individuals for alleged crimes committed in Ukraine, and that's why trials and Truth and Reconciliation Commissions, on the other hand, are really mutually exclusive. And the final point was made in a presentation that looked at the issue of transitional justice from the other side of the conflict. More specifically, it was suggested that it was not only Ukraine that needed a transitional justice mechanism, but also the Russian Federation, with due regard to the aggression that was committed by Russia against Ukraine, but also with due regard to some internal developments in the Russian Federation, such as for example, corruption. According to that speaker, a possible transitional justice model for the Russian Federation might better the situation with regards to the problems that were mentioned, and to sum up, if ever a transitional justice mechanism for Ukraine and or for the Russian Federation were ever established, this could potentially be useful for both countries, but also for the world, because transitional justice is not only a result; it is also a process that affects the lives of people, affects the state systems, and it also affects the everyday lives and processes in every country concerned, and ultimately transitional justice changes lives. Thank you.
Very much indeed, Sergey. Now, also for stepping in so quickly and so efficiently yesterday. And two more panels, two more workshops took place today. The timing was difficult because it's the second day of the conference and it's after lunch. Nevertheless, as far as I understand, judging on what I've seen and heard, everything went well. So workshop 5 dealt with accountability for violations of international humanitarian law, and it was moderated by Professor Olga Butkevich. So now, Professor Butkevich, the floor is yours.
Thank you very much. First of all, I want to thank all panelists for their interesting reports, and I want to thank all participants of our discussion who made it very fruitful and very interesting. I would be maybe too egoistic to say that our panel was of crucial importance for all other topics of our conference, because our panel was devoted to accountability for international humanitarian law violations. And IHL lays in the center of many other international legal problems connected with conduct of hostilities, with armed conflict, and with, as well as with post-conflict settlement. So we had we went from general problems to more particular ones. At first, Ashley Olsey showed us the concept, which was initiated as early as in Middle Age by Alberico Gentili. That was the concept of jus post bellum. And it was reopened in modern international law in the second half of 20th century in the process of peacekeeping processes. She addressed the problem of post-conflict settlement, of post-conflict regulation. Then Katarina Bussel took another topic. It was more particular, it was more specific. That was a topic of destiny of cultural property during an armed conflict. She addressed the problems of inefficiency of implementation by Ukraine of IHL rules and principles. Finally, Nadia Volkova treated another very special subject, very important topic, that was illegal, the issue of illegal detentions and forced labor during armed conflict. All participants of our panel paid particular attention. They focused on all these problems with particular regard to Ukrainian situations. And all of them stressed on deficiencies of Ukrainian legislature, on international humanitarian law, on implementation of international humanitarian law. While speaking about post-conflict justice, we discussed the problem of Minsk Agreement and the problem of consistency between international obligations, international commitments of Ukraine in the domain of international law, which prohibits amnesty for grave violations, and misunderstanding of Minsk agreements on the domestic level. While speaking about other humanitarian issues such as protection of cultural property, here Katarina Bussel showed us that Ukraine is enabled to implement many international legal instruments on international humanitarian law on the protection of cultural property, while Ukraine, by the way, Ukraine has signed and ratified actually all instruments on international humanitarian law, but is unable to implement it properly. Finally, Nadia Volkova showed us some deficiencies in law enforcement, in implementation of other Ukrainian commitments and obligations in human rights domain. And here I would like to sum up it, and I would like to make a brief conclusion that the problem is not about deficiencies with international commitments, international obligations in the field of international humanitarian law. The problem is more complex, the problem is more systematic. The problem is with correlation between international law and domestic system of Ukraine. Ukraine has the very same problems with other obligations in other spheres, in other domains. They're not so crucial today, but they exist. I would say even more than we have a collision between constitutional norm on the place of international treaties, international obligations of Ukraine, and all other laws of Ukraine and Ukrainian legislation. So the problem is very complex, the problem is very difficult, the problem lays in the domain of necessity to revise Ukrainian legislature and even Ukrainian constitution with regard to the place of international commitments. We have no place for international treaties in hierarchy of national legislature. We have no place for international legal customs, and we have no place actually for international principles of international law. So the problem is more complex, and it was stressed on by our panelists, and I'm grateful for them. Well, I will be more brief. On behalf of Ukrainian Association of International Law, I would like to thank all of you for participation in this conference. It was very nice to greet all our foreign guests, and we are looking forward to welcome you here and welcome you in our further scientific events on international law. Thank you very much.
Thank you, Olga. And last but not least, in parallel with workshop 5, we had workshop 6, dealing with the European Court of Human Rights and other regional or other human rights bodies, I'm sorry. It was moderated by Maria Isaeva. Maria, you have the floor.
Thank you. Well, first of all, I apologize because for some reason I'm completely brain dead after the panel, probably due to the lack of oxygen and a mix of kind of very quickly coming back to a very, like, to me, technical and professional things on the EHR after a very emotional morning and the lecture we had. So I hope, I mean, my wrap-up session makes certain sense, at least. So we had the topic of the workshop was ECHR and other human rights bodies. Most of the papers focused on the ECHR, and two were of a more general nature on interrelation between international human rights, humanitarian law, and philosophy of faith by John Morse on the international the right of the collectives, and our final presentation. So two of the ECHR related topics concern interstate cases between Russia and Ukraine that are pending right now. So Ralph Wild from the UCL spoke, well, gave a rough outline of how specific the interstate adjudication in the ECHR is, yet it's the most viable option given the court's jurisdiction that is already established. And he spoke on the extraterritorial nature of the actions of Russia and Ukraine, kind of suggesting us to make a thought experiment how the issue of subsidiarity, which is inherent, like the issue of exhaustion of domestic remedies, that is normally preferable and principle that the ECHR applies, how in this thought experiment it would hypothetically be even possible for Russia and Ukraine in the domestic legal systems of another. So the answer was basically that in the interstate, in this type of cases, the going to the domestic courts of another is technically impossible because there is not even the applicable law and the issues of immunity, etc. So the second paper on the interstate cases was given by Lilian Apostel, a former agent from Moldova at the European Court of Human Rights, and he analyzed and compared the cases brought against the interstate cases and the cases that he calls quasi-interstate, such as like individual cases, but that raise the implications of the interstate frozen, so-called frozen conflicts, such as Transnistria and Moldova and many others. Here, basically, he gave two scenarios how the court might resolve the cases based on the inter alia Moldovan experience. And the first is like Lashko, Transnistrian, that employs positive application doctrine and effective overall extraterritorial control. The second is basically Nagorno-Karabakh scenario, Chikarov and Sarkisyan, that employs mediation by attributing responsibility in what Lilian called crisscross manner without any preferences. Basically, and the interstate adjudication was generally called as a necessary evil as compared to the individuals bringing cases to the court. Then we had two P11 property presentations by Ivan Lishina, the current agent for Ukraine, and Gulara Guliva from Birmingham Law School. Gulara was addressing a specific matter of the impact of the property rights jurisdiction of the court or on the P11 case law on the international displaced persons. And the conclusion was basically that within this autonomous concept of property that the ECHR has, there are chances for the victims of certain delayed payments, and the number is high, right? It's 1 million people. Gular also drew on her personal experience from Azerbaijan, relating to what it feels to be a victim of like being displaced, homeless, and having. So the conclusion was that there are high chances for such cases to be adjudicated in favor of applicants against Ukraine. Which is what is interesting in this regard is that when we speak about this conflict, we normally think of Russia, but it's not only Russia that is going to be discussed in the ECHR, it's also Ukraine, and this presentation, was tackling this, the responsibility of Ukraine and the human rights law, which is still in place during the conflict. Ivan, speaking on the impact of Crimea, Donbass potential, the impact that might be on the ECHR case law, went through the case law, existing case law from Cyprus, Turkey, Azerbaijan, like Orhan versus Turkey on in respect of property during the hostilities and occupation and conflicts. And I think that there was something of a cross line with Alessandra's presentation that went later on the intersection between international human rights and humanitarian law. In that Ivan was saying that to him, so basically both speakers were addressing the issue of applicability of the international humanitarian law and the need in doing that. And to Ivan, the application of humanitarian international law, it was, if it was unlikely to alter the outcome in Cyprus versus Turkey or Sarkisian cases, it could influence findings of the court in Orhan and as Muhammedov case against Russia, and in all probability, and I quote, would deliver an opposite result in Bankovich. So basically the issue of the ECHR not dealing sufficiently with the international humanitarian law. So I would, and the last, the philosophical part. Well, here in the comments we, so basically the concept that John has, it's replacing the Lauter Pact idea of human rights as an individual concept with the rights of the collective. Well, here I would probably just respond that we need to be really careful because Russia domestically is now pushing the type of philosophy maybe that John was talking about, replacing the individual rights with some rights of traditional, or whatever, family, whatever kind of protected groups they're inventing every day, essentially. Or maybe not, but still. I was also thinking that I basically disagree. I mean, to me, human rights are individualist, but maybe in the term, in the times of conflict and war, that's where, as I don't know, as mankind, from outside, we turn. So if in the peacetime, like I'm here, if there is a war, like I will be, protected as part of the collective. So to me, it's a very difficult concept to grasp for peacetime. I will conclude briefly with the things that I would probably like to hear and that I didn't. So during this panel, I don't think we devoted any attention to the implications of Russia's attitude to the Council of Europe in general and to the European Court, and to the impact the judgments may have and how they will be enforced, because you probably know that Russia is taking a lot of actions supposedly aimed at the outcome of these interstate cases that can render the effects of judgments questionable. another thing that, and I will finish with that, that I thought that, and now I'm brain dead, so the thought is going away in a very good time. Throughout this conference, many people were saying about transitional justice and the need and truth commissions, and the question was raised: should we establish them now rather than wait? I never thought. I mean, to me, it's difficult because I've never thought about my profession, daily life profession of the ECHR and transitional justice at the time. But if we look at it from this perspective, as we tried today, then the ECHR is already doing the job as transitional justice thing. So we may want to have a deeper look at the judgments to kind of try to maybe even forecast what Ukraine will be dealing with if there is something. Plus, interestingly, whatever the ECHR is doing is taking us to Russia and our issue, which was raised by some of my colleagues here from Moscow, where we are now working on transitional justice, or some of our brave and courageous people working on the potential, like the transitional justice system that should be in place, they think, or some fact-finding should be done just in case, you know, it can never be implemented. But the ECHR cases against Russia and Ukraine, they will not only have an impact here, but they will create a situation kind of where we will need to be, you know, hoping again that the rule of law in Russia will be reinstated. And I thought that those are the implications that were not discussed, but maybe we should have paid some attention to them. But otherwise, it was excellent, and I will finish with that. Thanks.
Now, thank you very much, Maria. Despite the lack of oxygen, the panel was, the workshop was extremely rich, I would say, and I enjoyed it very much too. And thanks also for your more general observations. Well, let me thank once again to all the moderators and rapporteurs for this debriefing. It was a very useful one because it was very difficult to follow all the workshops. Some of us tried. I saw migration. I was also participating in this migration from one workshop to another, but nevertheless, I think it's good that we had this debriefing now. Thanks again, and without any break, I would suggest that we move straight to the closing session, and I invite, of course, Judge Yurkivska, Mr. Bushenko, Mr. Milanovic, and Mr. Lishina on behalf of the Ministry of Justice, I understand. Okay, so please.
Okay, shall we start with me? Well, let me just express once more my own gratitude for being here. It was a lovely conference. It was an intellectual pleasure, not merely an intellectual pleasure to be here. And I would express the gratitude also to the European Society of International Law, to all of you for organizing this excellent event in Ukraine. And I hope it is only the first of many to come. So I would also invite all of you to, if you're not already actively participating in ESIL, to do so, and to come to our next big conference in Naples, which will be as nice an event as this one. Okay, thank you very much.
Basically, I wasn't supposed to be here, but I apologize for Mr. Petrenko's failure to appear. He had a serious issue to resolve at the moment. So basically, I am on behalf of Minister of Justice. I wanted to thank, in the first place, our organizers, Thank you very much, Helsinki Foundation, Ukrainian Association of International Law. This is absolutely amazing event, I would say. Probably we never had anything like that in Ukraine. It is, I have no idea what kind of efforts had to be put into bringing together all these people from all over the world, coming to Kiev, which is basically in the center of ongoing armed conflict. I would say that, well, the fact that even some participants of, as we call it, another Russia came here and dared to be here is a sign that the name of the conference is not a sham. Post-conflict, we are still there, we are still in the middle of the conflict, but there are going to be something after that. The post-conflict, probably there would be serious issues to be considered. For me it was extremely useful because, you know, I'm still in the middle of this legal struggle related to this specific conflict. So I picked up a lot of ideas. Yes, the person from whom I picked up the most is sitting right here. Thank you, Marco, for being there. Okay. Yes, of course, this conflict is different from anything the Kurds had to do before that. All the conflicts before that were internal conflicts related to some kind of guerrilla warfare. Here we are dealing with a more or less equally balanced conflict. The only time the Kurds had to deal with that was in Bankovic case, where the Kurds decided not to deal with that. And now we'll see how far the Bankovic should go. Again, thank you very much for being here, and I'm thrilled that we managed to have this kind of conference at this time. Thank you very much.
Well, I don't think I'm well placed to judge this conference because I'm not at all impartial. This is our baby we were carrying for about a year together with Mikola and Arkady, and of course we are not impartial when it comes to our children. But I still believe it was a successful conference. Someone clever, I don't know, remember whom said that success is positive thinking combined with positive actions. We had positive thinking, positive intentions to start talking about post-conflict justice, and this conference was our positive action. And I've heard a lot nowadays, many of you that, oh, I got this idea, I got that idea, we will develop, we will discuss. And this is something we wanted to achieve. Of course, we never promised that we would immediately give some clear answers to all these difficult questions, but we started, and this was something that we really, I believe, we progressed with, and we will continue. And let me share with you what this morning I heard from my very dear friend and colleague, Judge Eric Moser, who led a bit early. He said that for the first time during past several years, he had seen such young, flourishing generation of international lawyers here in this room. So I really would like to thank all of you for being here, for thinking together with us, and I believe we will continue. Just to let you know that we started to plan a year ago, and on the way we lost several speakers. A couple of speakers we lost for bad reasons, but 2 speakers we lost, I believe, for good reasons. Judge Antonio Cansado Trinidad was supposed to be here, and Judge Fausto Poker was supposed to be here. But they could not come because they are participating in the case Ukraine versus Russia in International Court of Justice. So they're also working for post-conflict justice, but in a little bit another area. Yes, yes. But in principle, we are doing the same. We are bringing really post-conflict situation closer to, unfortunately, the current situation. We are still in the conflict. Thank you very much, all of you, once again.
Again, thank you very much for all you who come to this conference and create the conference, create this event. Because yes, we prepared it during here, but without you, it would not be come true. So I am personally very glad all what was happening there. Many thoughts, many subjects to think about, and thank you all. I suggest that maybe two things is important to sum up all these things that happened, that was said there. You know, I suggest that our government has two main mistaken point, that only Russian Federation is responsible for all bad things that is happening there, and that peace building, we start peace building after the cease of the conflict. It's too mistaken point, and I suggest that this conference may help to think in other way, more right way, to be. It's like some childish thinking, and I suggest that conference will help to be more mature and more sober in assessment of the events, in assessment of the responsibility of our state, because this conflict, yes, it was inspired by some external forces, but in the final, eventually, it's the problem of Ukraine, and we all are responsible for solving this problem. I want to thank our team. A part of the team is here, but there is team on the back of this conference that was not so visible. It's the team of Ukrainian Helsinki Union who secured all these things, fixed all these problems, and made it possible. And I thank again USAID for financial support and organizational support and ideological support of this conference. And again, thank you all for coming and your input in this conference. Thank you.
Well, dear colleagues, this is really, I'm very also humbled by just this coincidence that I have the final speech here. I shall be very brief, but I want to say that just 2 weeks ago, the Ukrainian international lawyers suffered a horrible loss, and you saw that on the first day of the conference, was passing away of the president of the Ukrainian Association of International Law, Professor Zadorozhny. And believe me, it's been very difficult 2 weeks for everyone, for all of us here. But now, today, I can say that I feel quite happy, because this conference has taken place, and it has taken place very much in accordance with the design it had. And this is thanks to all of you for being here, for your wonderful contributions, for being so interested in the subject, for your presentations, for the fantastic atmosphere that was created here. Let me thank once again, to begin with, first of all, and first and foremost, Judge Anna Yudkivska for the idea, for its implementation from beginning to end, basically, and for finding time to deal with this conference despite the extremely heavy work schedule of a judge of the European Court of Human Rights, and especially president of the section of the court. Also, many, many thanks to the colleagues and I can say friends from the European Society of International Law. to Marko Milanovic, who is now with us, also to the board members who were helping us. No one I think has mentioned Veronika Bilkova yet, but she really helped a lot with also with shaping up the program and with providing excellent input, and also of course to Professor Neukemper and to the team of the European Society of International Law in general. And of course to the Ukrainian Helsinki Union, Mr. Bushenko, Arkady Bushenko. He's an incredible person to work with. I think it's just you can't expect a better partner and friend. And his team, everyone who has taken care of this conference has been so impressive and so good. It's not such an easy task to bring to Kiev people from all over the world, as Ivan has mentioned. But well, you managed. Well, thanks, of course, to the generous donor, thanks to the USAID and so on, but nevertheless, without you, we wouldn't have even found that donor to begin with. So once again, thanks a lot. I hope that despite this being a very hard time for Ukraine, for the country, despite this being a particularly difficult time for international lawyers in Ukraine, I think we have a good, bright perspective ahead of us. Thank you very much. Thanks for everything, and, well, enjoy the rest of the weekend. And have safe trips home, huh?